Happy Friday, everybody. Happy Friday out there. So nice to see you. First Friday with Fran. Even though I saw you last Friday, you got to see me twice in 2 weeks. That's kind of brutal, I know, but I'm here. I'm back. We didn't really realize that this would be signed into law on Monday, which is great. So we had to kind of jump on it and get the word out as quickly as possible. Just so everybody knows, as usual with First Friday with Fran, this will not be exhaustive. This will not be exhaustive tonight. We're going to try and keep it to under an hour, right? And we could have an all-day seminar on this. We have a special guest with us today, Mitch Frumpkin, who's a professional engineer. Probably most of you know him already. He's the owner of Kipcon Engineering. Not only has Mitch been involved in reserve funding, inspection, structural issues forever, his entire career, he is also very much involved with this legislation and the development of this legislation. For those of you who have been on First Friday with Fran, you know I have the boring part in the beginning, which says these webinars are provided for general informational and discussion purposes only. These webinars do not and cannot form an attorney-client relationship. The information exchange does not constitute legal advice. To obtain legal advice, you have to go out and hire an attorney directly, enter into a retainer agreement, sign that retainer agreement, and present your particular facts of your particular association to that attorney, whether it's us or some other law firm. The other thing to keep in mind, no information discussed during this webinar will be kept confidential. And why is that important? I do not want people to raise their hand or go into the chat room and ask a question and say, hey, Fran, we just want to let you know my building is falling apart and we happen to have no reserves. So could you please tell me what to do? Don't do that, okay? Because this is being recorded and you have a couple hundred people watching you right now, and you don't want that all out there in the world. Talk to your attorney and talk to your engineers about that. So today we have the dog of the day, which we always do the dog of the day, even if it's a special event, and today's a special event. So we do have the dog of the day today. We actually have 3 dogs of the day. These are Michelle Sloan's Chow Chows. Chows are great. For those of you who know, Chows have the purple tongue, and that's what they're known for. And very nice dogs, very fluffy. So these are the dogs. It's a Hunter, left to right, Hunter, Bella, and Luna. And Eileen, we'll see if we get these Hunter, Bella, and Luna on the 2025 McGovern First Friday with Fran calendar.
Just want to point out, Fran, that she actually had the dog on the flag, which was pretty wild.
Oh, nice. That's great. So a second about how we got here. Why, Fran? Why is this so important? Why is this going to be a continuing discussion? This will probably go on for weeks now. I think we're going to do seminars all over the place. There are many other, my understanding is many other lawyers on this webinar with us. There are many other engineers on this webinar with us, which is fine. That's the one thing that's kind of beautiful about this this industry is not all the time, but I would say 99% of the time, we're all collegial and we try to talk things out and we share information and we learn things from each other, and we do seminars for free at no cost, and we learn from each other. We make mistakes, we correct mistakes, we get things done. That's our job in the community association world, is get things done and make them right? That's what we try to do. So thanks again for coming. There are lots of people here today. And how did we get here? We got here, this kind of in many ways grew out of tragedy, right? The June 24th, 2021 tragedy down at Champlain Towers South down in Florida there, and with a tremendous loss of life. And for those of you who don't know, one of the leaders in the community association industry in New Jersey passed in that incident. David Epstein of what was originally Wentworth Property Management, and then became First Services New Jersey. Him and his wife, unfortunately, both were lost in that tragedy. But the aim of the legislation we're talking about today, and that Mitch is going to talk about at greater length, is how do we prevent tragedies like that? Because even though Champlain Towers tragedy was huge and with a tremendous loss of life, it's not unheard of in New Jersey, where we've had similar issues come up. So not long after Champlain Towers, we had a deck collapse in, I believe it was Margate, Atlantic County, where one person was unfortunately terribly killed. And I myself have had a deck collapse in New Brunswick, and other incidents. There's case law in New Jersey where some of these issues have been addressed already. So for those of you who are into the case law, there's Ritz Condominium Association versus Thomas, where the association went forward and addressed a major structural issue, and a resident tried to stop the project, and the court, the appellate division, sided with the association. And Papello versus Tower West, similarly, where the association felt it had to address a major structural issue. A member sued to try and stop the collection of fees and so forth and funding the structure repairs, and the court again sided with the association. So this is not unheard of in New Jersey. For those who have not really looked closely at Champlain Towers, the board in Champlain Towers, at least in my opinion, outsider looking in, I was not involved in the Champlain Towers case. We do not represent Champlain Towers. However, from what I can tell, the board and board members bent over backwards. They tried their darndest to get things done there, to get things properly funded, to do the right thing, and they were stymied. At least, again, from an outsider looking in, they were largely stymied. So what I think New Jersey is looking at doing is several things, and they go hand in hand. One is, hey, if the building is responsible, if the association is responsible for maintaining, repairing, replacing certain items, whether or not they're common elements, the association must fund, okay? They must do reserve studies. They must properly fund on an ongoing basis, not with crazy special assessments, not with crazy loans out there, but on an ongoing basis, okay? So you have a nice, as best as you can, a nice flow, inflow and outflow of cash flows. And then the flip side of it, which is not the financial side of it, but more the physical side, and Mitch will speak to this in greater detail, is the major structural elements in covered buildings. And Mitch can talk about what is a covered building and what is not. But with respect to the structural inspections and the structural integrity of buildings, to make sure that these buildings that have the covered type of structural systems, that they are properly inspected on a regular basis, and that there's proper follow-up on those inspections and their follow-up inspections on a regular basis thereafter. There are other issues, like I said, in the outline in today's agenda, that the board is given the superpower to do things regarding major structural defects, so that you as association board members hopefully will not find yourself in court like Ritz Condominium Association did when it was challenged by a unit owner, or like Tower West Condominium Association found itself in court back in the day when it had to deal with major structural defects, even though a portion of the membership wanted to stop that or wanted to prevent funding it. So the board will have superpowers to do certain things going forward. Many of the things, just so you know, we can get into granular detail on this legislation. I'm not going to try and do that right now, but we're going to talk about some general issues. You can put questions in the chat, and that's fine. We may not get to all of them today. We may wind up having another Friday with Fran next Friday. This is, I would call this the hottest topic since COVID in our community association world. And, you know, thank God COVID has largely been tamped down, although we've seen something of a resurgence. This is going to be a long-term impact on community association living, community association budgeting, community association industry across the board. Okay, so it is a very, very hot topic, very important topic, and will be a very, very long-term topic. You will see, as all legislation is, you will see some of this, we'll call it fleshed out or clarified through the courts, because no legislation can be 100% perfect, and no legislation can really be read the same way oftentimes by two attorneys, right? So when two attorneys disagree, you're going to wind up in court and talking about whether or not this applies in this instance, whether this word should be construed that way or not. So that being said, reserve study requirements and timing. If it's been more than 5 years since the last time you've had a reserve study in your association, you have 1 year to get a reserve study done, right? Okay, so reserve studies are important. That's really, 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 really important. If you're a new community, and I'm not getting into the granularity of this in terms of when COs were issued and all this is general discussion, but if it's a new place, if it's a new association, within 2 years after the date that the board becomes homeowner controlled, right? So if you're one of these brand new associations, that's what you got to do. If the association has not, I'm sorry, if the association has a reserve study within 5 years since the last reserve study was done, it must do one within the next coming 5 years, which makes sense, right? So it's more or less a 5-year stand generally. All right. Funding requirements. This is where things get a little interesting. If there is a funding shortfall and the delta, the difference is greater than 10% of the association's annual assessments. Okay, I know that sounds a little funky. If the shortfall is greater than 10% of the common assessment, then the catch-up period is essentially 10 years, the earlier of 10 years, or when it would go below zero. That's the scary part for those, like I said, and I'm sure some of you on the call that say, well, wait a second, we don't have any reserves, Fran McGovern. We never had them. We don't care about reserve. We've never cared about in the past. We don't care about in the future. You got to care about them now, right? So it's, if the shortfall, if the delta is greater than 10% of your annual budget, you have 10 years to catch up, or when it would go negative. And many, many associations would go negative. Mitch is going to put up charts that explain how this cash flow would work on a negative basis, and talk about that. So that is the requirement in terms of making a catch up. Mitch, do you want to say a few words?
No, you've nailed it so far, so we're good.
Okay, can you speak to the differences between the types of reserve funding, the full funding basis, the threshold funding, and then the baseline basis, so people have an understanding of, does this mean I'm going to have to put away $5 million tomorrow?
Well, I think that the starting point may be what does the law require? And can I give Fran, do you mind if I give a little background first?
No, go ahead. Sure.
All right, so if I can share my screen I would appreciate it. By the way, thank you very much for inviting me. As you probably all know, there's a huge amount of questions about this, and this is probably at least the third or fourth webinar I've given on this in the last week. And usually we have this size of a crowd, and I actually see some of the names here have been there before. So I guess I didn't explain it too well, but just a little background. Exactly like Fran said, this started with the collapse of Champlain Towers. And Champlain Towers, absolute tragedy, but at the same time, out of tragedies come good things in terms of what we're talking about today. So what happened after Champlain Towers, and I'm not going into, I'm just going to use slides as I need them because I've got a lot of slides about this. So with the different topics, I'll just jump to those slides. But what happened as soon as Champlain Towers collapsed, very soon after that, CAI National put together a task force that developed this book on the left-hand side here called the Condominium Safety Public Policy Report. I was one of the co-chairs of that committee that we put this together. There are about 600 people across the country involved in it. But essentially, this came up with specific requirements based on the recognition that safety is not based on just reserve studies. It's based on reserve studies, structural integrity inspections, and maintenance. And very key point that all three of them together are what keeps our buildings safe. So CAI came out with that conclusion very quickly as part of this public policy report. By the way, any of these reports I'm going to mention, they're free reports that can be downloaded from CAI National's website. Or if you'd like, I don't know, Fran and you guys have copies, but we can distribute copies of these publications if you like them. So what CAI did was they said, okay, there's three things that would keep our buildings safe. So in the public policy report, it talks about structural integrity, how often, what, all that kind of stuff. But it was clearly recognized that the reserve study standards, which are used nationally, that everybody uses, only talks about reserves, and it does not talk about structural integrity or maintenance. So another task force was created, which you'll see how I spend my life. I was one of the co-chairs of that task force. And we modified and updated the reserve study standards to reflect safety, structural integrity inspections, and maintenance. And if anybody has any questions about this stuff, just let me know. I'd be happy to answer. So then we also realized that maintenance is an absolute key part of this, and there's no publications by CAI having to do with maintenance. So then again, I was on a task force that developed the Community Association Best Practices Report on Maintenance. So CAI did this pretty quickly. I look at what's going on in the world, and if it wasn't for what CAI National did, we wouldn't be where we are today across the country. As a matter of fact, in Newcastle, Delaware, they have come out with legislation they voted on about 4 or 5 months ago. I was asked to be on that task force, which pretty much matches the public policy. And then Senator Singleton in New Jersey approached us and said, I want to put together legislation based on CAI's public policy. So a few of us worked with Senator Singleton for a while. We've been working on this for a while and developed legislation that we're going to talk about. Clearly, this legislation went through a process where, depending on the interest groups, there were changes made. I'm happy to go into that. But the ultimate document that we're talking about to the right here was just approved last week. It was approved by the Senate in New Jersey a couple of weeks ago. It was approved by the Assembly. And then because it was a lame duck session, it had to be approved or vetoed by the governor by the end of the 8th of this month, which he approved it. I will tell you, which is going to be hard for you to believe, and I'm talking pretty fast, but this was a nonpartisan vote. Everybody was in favor of this legislation. So it was nonpartisan. Is that the right word? Nonpartisan, because most people don't know what that word means these days. But
That's right.
it was nonpartisan vote, and it's been approved now. So it is law as of effective the 8th, because it becomes law as soon as that happens. So there's two parts of it. Fran, you brought me directly to the reserve study part of it, which is fine. But I can go to the structural integrity of however you want to do this.
Yeah, let's do let's speak to reserves first, Mitch, because I think they're equally important, but I think a lot of our audience today, especially the board members, are thinking about show me the money.
Yeah, that's fine. And I will tell you, show me the money, just so everybody recognizes that, and I'll show you why it solves a problem in the state of New Jersey where the cost of living in our communities will actually go down. It will not go up, at least in the long term. It will go down.
Mitch, can I interrupt for 1 second? I was remiss in one thing. So Mitch had mentioned various committees and so forth, and I do want to give an honorable mention to a number of people who were instrumental in this. Ed San George of Integra Management, Mitch, obviously, from KipCon, Dave Ramsey from Becker Law Firm, Governor Murphy, of course, Senator Singleton, Senator Greenstein, Assemblywoman Lopez, and Assemblyman Wimberly. So and CAI New Jersey also had a safety and structural integrity task force that worked on this, and Ed San George was the chair. So for those of you who have ever been involved in politics or legislation, politics is a way of groups of people making things work among themselves, even if they have divergent interests. So Mitch had mentioned earlier that these people had to work very hard with various interest groups to try to get us where we are. So as all of you should know, legislation is in many parts, as President Johnson said, the art of compromise, the art of the possible. So you'll see in the legislation that things like apartment buildings, interestingly, are not addressed in this legislation. But I did want to highlight, and sorry for interrupting, Mitch, that there were individuals, and I'm sure there are a lot of individuals that I'm leaving out, that were instrumental in working on this legislation and getting it into a form of where it is today. Working through the legislative process in a bipartisan way is extremely difficult, as we've seen in our federal government lately. But Mitch, sorry for the interruption and the digression. Roll with it. Sorry.
No problem. I have to say that you're absolutely right. Originally, Senator Singleton wanted this for all residential buildings, whether they're apartments or community associations. We got huge pushback from the builders because of that and the apartment association. So Senator Singleton decided that I better take what I can get and stick to associations and get out of this the rental properties. And the rental properties came out of it. I remember a meeting when somebody said somebody was pushing back against it in one of the committee meetings that we were at. And he says to them, well, what's the difference between an apartment building and a condo as it gets older? They're the same thing. They should both be included. But it didn't matter what he said. As you know, in politics, sometimes your constituencies can really push back. So that's why it came out of there. So, but from our perspective, representing the association marketplace, it really didn't matter to us because we were here to protect associations. And if the apartments don't want to protect themselves or whatever, that's their choice. But we got what we wanted. Let's put it that way. So before, I'm going to just show you one thing to show you how this solves the problem in New Jersey. And if you look at this chart, This chart is showing, so on the right-hand side, I think everybody's pretty familiar with it, shows a cash flow. A community is brand new. It starts collecting money for reserves. And as things get replaced, they replace it and the line drops down. Now, in the state of New Jersey, you may or may not know this, but there is statutory requirements right now. It's been in existence for a long time that says when a developer creates a community, as part of their budget, they have to include a reserve study and fund the reserve study. So if you look at this red line here represents developer and control, association and control. So you follow this line up, and there's the developer has a reserve study, is funding the reserve study, blah, blah, blah. Then what happens? The association takes control. And what do? In many, many instances, because of the cost or whatever is involved, they're not funding their reserve studies adequately. So you go on, you drop down into this yellow line. So what's happening is if somebody's living under a roof for 20 years and there's no money, then when they move out and somebody new moves in, there's a special assessment and somebody else is paying for the roof. You know the logic behind this. But so what happens is you go into this yellow line in a lot of places, and then when it's time for replacement, what happens? It drops into a deficit, so you have to have a special assessment or borrow to replace your roof. What this legislation requires is that the community association now has to continue doing reserve studies, as Fran said, and fund them at an adequate level so this doesn't happen. So the only place where you're going to find communities that are going to have problems with catch-up periods and things like that are those communities that when they took control of the association did not continue funding the way they should have. So I just want to point out how this is going to solve a problem. Now we go to the legislation. These are the actual words. And if anybody wants a copy of this, we'd be happy to provide it. It's in the public domain, so to speak. And any association shall undertake and fund a capital reserve, shall fund a capital reserve study, which shall determine or assess the adequacy, which I'll talk about in a second, of the association capital reserve funds to meet the anticipated cost of replacement or repair of the capital assets of the common and interest community association. Keep in mind, all reserve studies shall be prepared in conformance with the CAI National Reserve Study Standards. There have been some changes that have taken place in that, which were just approved recently, that also affect how reserve studies should be done, in addition to what the state requirements now require. So those standards have just recently changed also. But the CAI Reserve Study Standards, a capital shall be performed by, keep this in mind, it's very specific that it has to be performed by somebody who has the expertise to do these studies. It's somebody who has the reserve specialist designation from CAI, the RS. It says who's credentialed through the community association, or an engineer or architect who's licensed in the state. So keep in mind, when these studies are done, it has to be done by an RS according to the statute, or a licensed engineer or architect. If it's a licensed architect or engineer that is not an RS, they still have to do it in conformance with these standards. So keep in mind, it's very important, the qualifications of the person who's preparing the study. It goes on to say that the study shall include the association's capital reserve fund balance. All reserve studies include that now. It's the beginning balance. The association's anticipated income and expenses. That is not in the national standards, but it needs to be provided. So what's your association income and what's your expenses? The other thing is an analysis of the physical status of the common area components of the buildings and other common areas that are the association's obligation to maintain. That really doesn't change. The national standards are very specific on how you select the components to go on your schedule. I will tell you, for that without going into a real reserve study seminar, that the 30-year rule is gone. The way you select the components is in the national standards, but it has changed. All right, the analysis, and then it goes, the anticipated costs associated with the building maintenance. The reserve study standards do not require you to include the cost of maintenance. This is a statutory requirement, is not in the national standards. What the national standards say in regards to maintenance is that one of the disclosures in the reserve study has to be whether or not the community does maintenance. If the association does not do maintenance when the study is prepared, that is reflected in the estimated remaining lives of the components, where if you have just a component that's a 20-year life, you don't do maintenance, that useful life may be reduced by 5, 6 years, whatever it is, which means you have to accumulate the money faster because you don't have it. because you're not maintaining it. So, but
Mitch,
that's,
can I interrupt for
yeah,
one
please.
second?
If I'm jumping too fast, go ahead, Fran.
No, I just want to go back to 3 for a second. And you and I have talked about this in the past. I wanted to get your feelings on what that means, right? So the analysis of the physical status of the common area components, it's not just common area components, it's whatever the association takes care of, is obligated to take care of. So we have many associations where they're not common property, they're townhome style, but it then doesn't own the roof. The association may not own the roof as common property, but the association is obligated to repair it. Does this 3 mean that in a reserve study update, the reserve specialist or the engineer, the architect must go out in the field and walk around?
Oh, that's a great question. Absolutely great question. Yes. According to these requirements, it includes a field inspection. There's something called what we call like a level 3 study or something, which is just a paper update. But in order to do the study according to this standard, it needs to include an evaluation of the status of the components, which means looking at them.
So are you saying, and I'm not trying to be a lawyer here, but are you saying that the old school paper updates are by the wayside now?
Well, they're by the wayside as far as a statutory requirement for funding, but there's plenty of associations that will still use them. For example, if they want to see how much will it add to their reserve if they're going to add a new tennis court or something, just to do that kind of evaluation, they'll still be used. But to do an update to establish your funding based on it, they're not going to be used.
Thanks.
And most places didn't use them before.
Thanks.
The other thing that's interesting that you said is that most people look at the definition of the common elements to decide what to include. But what happens if you have an association where it says, and I think what you just said was, the roof is not a common element, but the association is still responsible for replacement of that roof, right? Then that would go on the reserve study.
Right. Very common. Very common. Yep.
So
roofs and siding. I have a number of associations where the roofs and siding are not common elements or common property, but the association is obligated to maintain, repair, and replace.
right. And the other thing to keep in mind is that in the past, when you were doing an update of an old reserve study, the standards just required you essentially to update the prior study and not look at whether or not additional components should be added. The standards now are very specific. When you do an update, it has to include looking at the components. And if there are components now that were not included in the study before that should have been included before, they have to be added. It's part of the standards, and this relates to the standards. So that goes to the old 30-year rule, not to really jump around and drive you crazy, but it used to be that any component that needed replacement within 30 years would be included. Now it's long life of components are included in reserve studies. And as you're doing updates, you have to add those to the study. So there's a number of changes that took place in the national standards that also relate to this, because it says use the national standards latest update. But now here's where you start getting into things that were not included in the standards, but are included in the statutory requirements. The anticipated cost with building maintenance, which I said, so that the anticipated cost of building maintenance now needs to be included as the anticipated cost of repair and common area building, as the anticipated cost of repair or replacement of common elements which are necessary to maintain the structural integrity. So it says the anticipated cost associated with building maintenance, as well as the anticipated cost of repair and replacement of common area building components, which are necessary to maintain the structural integrity of the buildings and other common area components that are necessary or associated to maintain. So essentially, the structure of the building is not included in a reserve study. That's just, they're not included because they have a very, very long life. But the cost of maintaining them so they attain their full useful life and the things that protect them need to be included in the reserve study. This is something that's in the statutory requirements that is not in the reserve study standards. So everybody has to be very careful to meet the law. You can't just say, call up an engineer and say, give me a reserve study and not tell them that it needs to meet the statutory requirements, the national standards. And I would say, at least in the beginning, you need to be clear about what does the statutory requirements are they in terms of reserves. One of the things that we're doing, and if anybody wants a copy of it, I'd be happy to share it. We're going to prepare a generic RFP for requesting a proposal for a reserve study based on these standards. So it's pretty clear what the intent was and what should be included. Then,
Hey, Mitch, I don't mean to interrupt, but somebody's asking a good question. How about something like a retaining wall in a community association?
Well, the question about a retaining wall, whether or not it should be included?
Yeah.
Well, I mean, if it's a wood tie retaining wall, absolutely, it should be included. If it's a block retaining wall and it has an estimated useful life, let's say of 40 years based on industry standards, if you look at the new standard based on long life components, there's two ways to do it. And I'm giving you really some of it, getting in the weeds with this, but there's two ways to do it. Either to list it on the study and show its useful life, so it's very clear that when it gets to 30 years, it needs to be added, or to add it at that time, so it should be added. Now, the difference between the two is, let's say it's new and it's 40 years, and you add it then you're amortizing the replacement cost after a full 40 years. Option one. Option two is to add it when it gets to 30 years. Now what you're doing is you're funding something over 30 years instead of 40 years, so it's going to cost you more per year to do it. So there needs to be discussion with the client about the ways to do this, and I'll get into in a second the funding plans because those tie into it also. So
just to add to what Mike and Mitch were just talking about too, is retaining walls are a good example of what a field inspection may really help in terms of useful life, right? Because, for example, Mitch and I think I've been involved in cases like this. You think that a block retaining wall will last forever, or at least more than 40 years or 30 years, right? So as Mitch said, that can be dealt with different ways in reserve funding. However, what if you see displacement in the wall in the field, or a bulging in the wall in the field that perhaps doesn't have to be replaced today or repaired today, but it may be a much shorter useful life projection for the retaining wall itself.
Right, or a section of the retaining wall. It doesn't mean 100% of it has to be replaced just because a part of it's falling down.
That's correct. That's
right. There's a tree behind it or something, who knows?
That's right.
A couple other things that number 5, a reasonable estimate of the cost of what? When you do your budgets now, when you should be updating your reserve study every 3, 4, or 5 years, 5 years maximum, but when you're updating, where do you put it? How many associations put the cost of that in their budget so it's accumulated over time? A lot of places do not do that. The statutory requirement is that you have to fund for your reserve study update as part of your reserve schedule. So it's a place in there when it comes time to replace, you have the money to do it. I'll also go back to Fran had said that this requirement in here is a maximum of 5 years. That means a maximum of 5 years. And the reason I say that is because depending on the type of funding plan you use, which we'll get to, the reserve provider may say that you should update it in 3 years, not 5 years. As a matter of fact, the national best practice is for updating reserve studies is 3 years. 5 years is the maximum, but the best practice is 3. But whatever it is, it should be funded in the reserve study. And I promise you, and you all know, that the funding of the reserve study update is nothingness compared to the total replacement cost in that study. But so it should include the cost of the reserve study update. The other thing is, which we haven't gotten into, but that if you are a structure type that requires the periodic structural inspections in conformance with this law, those periodic structural inspections need to be included in the reserve study for the cost. So for example, if it's 10 years until you need your next structural integrity inspection, and it's going to cost $10,000, that should be funded in your reserve study. While I'm on that topic, I don't want anybody to think that just because you need a reserve study, which is for all associations, that all associations also need a structural integrity inspection, because the structural integrity inspection criteria is not the same for every association. And the majority of associations will not need a structural integrity inspection. It's based on what material they're made out of, whether it's structural steel, reinforced concrete, we can get into that. But I don't want you to think that everybody has to do a structural integrity inspection as well as reserve study.
Mitch, let's just breathe for a second there. I'm sorry.
Okay.
Just breathe for your speed's great, but I just
There's
want
a
to
huge
breathe for a
amount of
second.
information.
Yeah, I just don't want to gloss over that really important distinction between covered buildings and structures versus excluded buildings and structures. Can you just speak to that for just as a footnote for a moment, just so people don't get confused?
Absolutely. I'm going to go here and show you that a covered building.
Now, this is just for everyone out there. This is just as to the structural inspection requirements. The reserve requirements apply to all the associations.
That's right.
What Mitch is now speaking to is the structural inspection requirements. So there are covered buildings and structures, and then there are excluded buildings and structures.
Right, and it's a good jump because I'm going to show you what the type of buildings that require structural integrity inspection are, which also require a reserve study. But there's plenty of that don't have these kind of structures. So, but the structural inspection is based on a building that has what's called the primary load-bearing system, which is made out of, this is direct from the law, it's made out of concrete, masonry, steel, heavy timber, and a few other things. So if your primary load-bearing system of your building is made out of one of those materials, then it will require an inspection. The definition of primary load-bearing very simply is that if any one piece of your building rots away, a building totally or partially can collapse. So for example, this is a primary load-bearing system made out of steel. If that diagonal disappears, the wind can blow it over in that top. If this column disappears, it can collapse. If this beam disappears, it can collapse. That's what a primary load-bearing system is. But the type of buildings that are not included as part of a structural inspection are a building that's made stick frame. It's just a million pieces of wood 2x4s. The reason for that is because any one of those 2x4s disappears, the building isn't going to collapse. It's a very repetitive design, so it's excluded. But I will also mention the majority, I think, of the buildings in the audience today probably are excluded buildings from structural inspections. But if you have a building that's like this, that's concrete on the bottom and wood on the top, and there's a fair amount of those out there, the concrete needs to be inspected, but the wood on top does not. So,
and Mitch, just as a term of art, what's the term of art for that?
this is called a podium deck. A podium deck is the terminology. So if you look at the statutes, it says podium decks are included. And a podium deck essentially means something that's supporting something on the top, like that. You'll see podium decks a lot above parking garages and things like that in high-rise buildings. But the other thing to keep in mind is the buildings that require structural integrity inspections are not defined by the height of the building. They're defined by the materials they're built out of. So don't just think it's high rises. So now let's get back to the statute for the reserve studies, or the law for the reserve studies. The reasonable cost of the reserve study, periodic inspections if you need them. The reasonable estimate of cost associated with implementing corrective maintenance. Now, what that means is if you go out to inspect your community and something is broken and it needs to be fixed, that fix is called corrective maintenance. So one of the things that's changed in the reserve study standards is it used to be that it was for cyclical replacements. Every 20 years, you have to replace the roof, every 20 years. But if there's something now that you see that requires to be fixed once because of corrective maintenance and something is wrong, it goes on the reserve study, but you only have to put it in there for one cycle because you won't need it again. So that's why the reasonable estimate of costs associated with implementing corrective maintenance deemed necessary pursuant to the structural integrity inspections, jumping around, because they require that be included. Now, I know I'm jumping around. If you have questions, feel free to jump in, but now let's get into the funding. It says that the reserve study has to include a proposed 30-year funding plan, a 30-year funding plan that establishes the adequate proposed capital reserve funding over a 30-year time period. The 30-year funding plan is something that's been in the CAI standards. It used to stay in the past a minimum of a 20-year funding plan. The new standards say it has to be 30-year funding plan. Most people in our geographic area, all the reserve studies I've seen from my firm and everybody else's includes a 30-year funding plan. So that's in there already. So that's in your studies when you get them. So, but I'll get into what adequate means in a second, which Fran went over. So it says any information necessary to perform this evaluation. So when we do a reserve study now, we will ask your association, do you have any inspection reports on any of the buildings or the site or anything in your community that have been done that we can use as reference in preparing the reserve studies? That's one of the things that we're going to be, what we ask for is for any information like that, any other information necessary. Let's see. Now, Fran touched on the makeup period. which I'm not going to get into again, but I'll show you a little charts about how it works. But it's exactly what you said. And let me go to.
One thing I left out, Mitch, was if the delta is under 10%, the makeup has to be made within 2 years, 2 fiscal
2 years, exactly, yes. Now let's briefly go over the funding plan options, which I think you all pretty much know what they are. This is the 30-year funding plan. The top line is called full funding. What that means is, and you can use, there's a few different terminology, but I'm going to keep it to full funding. It means that every single component is fully funded. So if it's $100,000 with a 10-year life, that's $10,000 a year. So after 3 years, you should have $30,000. You do that to every component and you add it up, and that comes out to this full funding. Other terminology may be the component method, a few different things, but essentially that's what that top line is, full funding. This bottom line, this next to bottom line, this green line means that you've taken your annual contributions and you've reduced them. Instead of $1,000 a year for full funding, you've reduced them to the point where the lowest point on that funding plan drops down to 0. Now, what that means is if this component needs to be replaced a year earlier, or it costs $10 more, you're running into a deficit. That is the definition of adequacy in the standards, in the statute. That is it. Now, if you look at the National Reserve Study standards, it's a little different, and because this is the most risky way to do it. But when we put together legislation, everybody wanted to include in something there that was very easily measurable. So the measurable thing is if it drops below 30, below 0, within that 30-year funding plan, you're inadequate. It's not adequately funded. Now, I'll just show you 2 other things which aren't really in the statutes, but this red line is just showing an association's actual funding. So you can see they have a problem because they're running into deficit here. The other thing is this orange line, which is called threshold funding, which is somewhere in between baseline and full. But the point is, because it seems to come up a lot, is are we limited to a certain type of funding plan? No, you are not. You can fund any way you want as long as it's above baseline so that you're adequately funded. So anybody have any questions about that? Because there seems to be a fair amount of questions about that. Okay, now let me show you this. Here you've got, what about this catch-up period? Here we are, here's an association that they do a reserve study. You're doing your reserve study based on the statutory requirements now. Here you are, this red line, you're doing it in year 2028 or whatever year it is, you're doing your study. And you see that this is your funding, the yellow line. If you continue on this yellow line, you're going to run into a deficit, okay? Now, in this case, just the common area assessment is $300,000. The increase to reach adequate reserve funding would increase it by $35,000, which is 12%. So you're over the 10% rule. If you're all with me, you're over the 10% rule. So now you have 10 years to catch up to adequacy. So here's what we're doing. Here's the 10-year catch-up period. You determine you're inadequate here. So over these 10 years, you have to catch up to have enough money, and then you can go back to the other funding plan, but you've caught up already, so you will not run into a deficit. Your line will continue like this. It'll drop down, and you're going to be at baseline funding, so you will be adequate. Again, keep in mind, I'm not saying that dropping down to 0 is what you should do because it's kind of risky, but I'm just using the definition of adequacy from the standard. So this is the 10-year catch-up period, but let's say you run into a situation that in 5 years, as Fran mentioned before, in 5 years, you have to replace something, so you're going to run into a deficit in 5 years. That means you don't have 10 years to catch up. So you have to catch up either in a maximum of 10 years or within the number of years you have so that you don't run into a deficit when a replacement takes place.
Hey,
Everybody with me on that?
Mitch, just to interrupt for a second also, when we're talking about the different approaches to reserve funding, so full funding, threshold, baseline, is it true that if you're going with baseline or a lower threshold, you should probably have more frequent reserve analyses?
Great point. That's why I mentioned before that it says 5 years maximum. If we do a study for an association that is baseline, we may recommend that they update it every year because of the risk involved. The other thing to keep in mind, which the new standards talk about where some of the risks come from, is the new standards say, the old standards said the reserve components are based on what you can see essentially. there's come to a realization that there are common elements behind the walls that you can't see. So if you know that there are common elements behind a wall, like plumbing and these type of things, there are common elements that will require replacement. These things need to be included in the reserve study somehow. So you need to include things you can't see, which is the right way to do it. But you can see that there's a number of things going on here that may adjust what threshold you want to use, because you've never, for example, you have a reserve study, you've never included things behind the wall. Now we don't want to go down to baseline because we know there's things behind the wall, we may increase it. So you really need to have a discussion with whoever's preparing a reserve study to talk about all these things to come up with adequate funding for you. But so this is the example of if you have less than 10 years because something has to be replaced, and then just keep it. Then if it affects less than 10% of your budget, it's the same thing, except you have 2 years to catch up. Or let's say something has to be replaced in 1 year, or you're going to go into deficit, then you have 1 year, but it's the exact same thing. And let's see, I think I may have touched on everything having to do with the reserves. The other thing, there's a disclaimer in here. If your community has less than $25,000 in total common area capital assets, they don't need to do a reserve study. This section shall not apply to an association with less than $25,000 in total common area capital assessments. Probably everybody in this audience has at least $25,000 worth.
Let me just add a footnote to that too, Mitch. So yes, I'm not trying to make this into granular legal advice today. So if you feel that your association may be exempt based on the $25,000 limit, say you're just a 2-unit condo down in Seaside Heights or somewhere, and all you have is a roof, okay, maybe you should talk about it. But as Mitch said, the vast majority will be covered. Also in the chat, Marv mentioned that there is applicability, and he says all associations is not true. So Marv's point is well taken when I was speaking generally, but there are very narrow exceptions. It's not about. I think Marv, your comment is probably a little incorrect there. This does not distinguish between retirement communities and non-retirement communities, at least in my understanding of it. So let's not go there. But if you have any question regarding the applicability of this statute to your association, please speak to your own engineers and your own lawyers. I will say, though, that the vast majority of associations that we work with will be covered by the reserve funding requirements here. There's not any distinction that I have seen between active adult age-restricted communities and your regular non-age restricted communities. But thanks for the feedback, Marv.
The other comment I make kind of along those lines is, even without these statutory requirements, there are other requirements in terms of reserve funding. For example, Fannie and Freddie are pretty specific in terms of what their requirements are. So you should be doing that probably now, because the Fannie and Freddie requirements in terms of refinancing and loans have been in place for a while, even though they've made it a little more stringent recently. Last thing I want to mention about reserves is that people are so concerned about the cost of this. And let me just show you this. If you take a look at the cost of preventive maintenance for a community, it's estimated by industry standards that preventive maintenance will cost you about 5% of your replacement costs divided by the life cycle of a component. Just an industry standard. The other thing is, if you don't do preventive maintenance, and because of that, you need to do corrective maintenance, which I talked about before, the cost of corrective maintenance is generally at least 30, 40, 50 times the total cumulative cost of the preventive maintenance. So it's going to cost you a lot more if you do not do preventive maintenance, which, keep in mind that the statutory requirement is that it be included. Now, let me show you the connection of how they're all connected. This is a podium deck here, which we talked about before. This podium deck has decking on top of it and a membrane to keep the water from going through. So what happens is that membrane is in your reserve study. Let's say it has a 20-year life. Let's say you don't maintain it, so only has a 15-year life. You're going to replace it sooner, and it's going to cost you more, and you may have a special assessment. But also, think about this. The structure of the building is underneath this podium deck. So if you don't maintain it and water gets through, It's going to rust out the structural steel underneath, supporting the podium, supporting the building. And then it's going to cost you millions of dollars more than what you would have spent just to maintain it and keep the water going through. The bottom line is preventive maintenance is going to reduce your life cycle costs. And this is an example of a high rise that we work with, where what we did is we said, we reduced the useful life by industry standards of all the components because they're not maintained. Then with preventive maintenance, we added 5% for the cost of preventive maintenance. Over a 30-year period in this individual case, just based on the reserve study, they'll save $2 million. And it doesn't even take into account how much more it's going to cost them to fix things. So the ultimate thing is that if you do preventive maintenance, if you do inspections, and you do the reserves over the life cycle, it's going to cost you significantly less to maintain your property values and to fund your reserves and things like that.
Okay.
I don't think I have time to go through the structural legislation.
No, I think what we'll do, so it's almost 5 o'clock, but what maybe we should do is I'm going to go through some questions. Mitch has highlighted some great issues. The people in the chat have highlighted some great issues. And again, these are going to be subject to seminars at the various annual conferences, et cetera. And I can tell you that myself, Mike, and Mitch, and various other professionals in the state are going to be doing regular seminars on this to try and flesh out the details and answer your questions more fully. And as Mitch said, be putting out things like form RFPs and other forms and bullet points. So people in the chat have asked, hey, Fran, can you send us over some bullet points in easily understandable language, so you just have that in a card in front of us, and we'll do that. And when Mitch puts together his form RFP, we will distribute that to our entire constant contact list here. So what I'm going to do right now is I'm going to blast through some questions without Mitch or Mike or any of us addressing them at the moment, to just put some thoughts in your head, because if we hung up on every question here, and then I'm going to get to the chat, I have some questions from prior to today's chat, but then I'm going to have some questions to review on the chat itself. And we'll try to answer some of them on the chat itself, but I want to alert you to the importance of some of these things by some preliminary questions. So some preliminary questions. Will mortgage companies demand copies of structural inspection reports and reserve reports and documents? The answer is, as Mitch already alluded to, yes, they will. More than likely they will, and more than likely they'll be asking for more and more and more and more. Fannie Mae, et cetera, are already asking for these because they want to know the financial status of the community. They want to know that the members who are buying in there can afford to pay, to the carrying cost, if you will, maintenance, repair, and replacement of living there, right? So the goal of this legislation, in addition to not having buildings fall down and not having maintenance put off, is to have a consistent cash flow so that the associations can be run without the need for special assessments and without the need for significant borrowing. You see what I'm saying? So that when people buy into these communities, they know what they're buying into. Because as many of you on the call with us today know, if you have associations with significant special assessment exposure, what does that do for law firms like mine? It creates collection work, right? Collection work, a lot of debtors. And the reason for that is people bought into under one certain understanding, and then they are zapped with a different understanding in terms of cash flow and expenses going forward. So you have to be very careful about that. And there are provisions and we're not going to get into them today, in the statute to provide more transparency to the members and even prospective members with respect to the cost to maintain, repair, and replace various items and the reserve position of the association, so that people do have a better understanding of how the communities are funded. So I think the answer, and Mitch alluded to this, is mortgage companies and other lenders and underwriters are going to be looking at this. What about home values? Will this impact home values? I don't know. I'm not a savant, but I think generally speaking, in the financial world, when people understand that there are more expenses than previously anticipated, oftentimes the value of the asset is reduced because they know that there are outstanding deficits, right? Where historically in our industry, we'll say the financial obligations are not always clear to the residents the existing members or potential owners, right? There's just not a clarity there. So you don't know what you're getting into. 2008, 9, and 10 have really revealed that to us, because we had many associations where 20% of the association's budget was in arrears, and or 20% of the association's members were in arrears. So horrendous. So you want people to understand what it will cost. Will insurance companies demand copies of structural inspections and reports? Probably so, right? That's a scary thing. What about underwriting, right? Because for anybody who has any knowledge of Champlain Towers, you know that not only was it a personal tragedy, awful, it was an insurance debacle, right? The insurance companies paid millions upon millions upon millions upon millions of dollars there, as did other vendors and people related to the association. So there, I think if you ask the question, I don't know the answer, but I think it's very likely that underwriting is going to be looking at this stuff. Will auditors, Mitch alluded to this before too, will auditors be looking at this information, whether it's structural deficiencies, reserve makeups, and so forth? I think the answer is going to be yes. I think auditors are going to issue requests to their attorneys and management companies, and they're going to want feedback on what the delta is in reserve funding. They're going to want feedback on what the structural inspections say, and if any of these things are material, whether they should be reporting them in an audit or not. I am not a CPA. I don't know the standards under the CPA, but this is going to be a significant issue. Some people in the chat said, hey, Fran, where is the liability? Where is the enforcement? Is the DCA going to be running around inspecting all of these buildings? Well, they may, as part of the 5-year standard, I think Mitch mentioned this too, as part of the 5-year standard inspections, they can do the structural inspection at that time. They can. But the question is, are they going to be doing enforcement? The answer is the statute as it's written does not provide for enforcement. However, the DCA has been a little funky lately, and you know that there's an outstanding lawsuit involving the DCA and enforcement of regulation, and whether the DCA had the authority to issue regulations and penalties, et cetera, under the Radburn law. It issued some regulations that many people feel that it was outside the scope of their authority. So even though this statute doesn't impose those types of penalties, or in my opinion, authorize regulations that would impose penalties like that, there is always the risk that the DCA will do something that we don't anticipate, and we may see something like that again. I hope not. But the big question is, where would possible civil liability lie? Where would the claims come from? I think you're going to see cases based on these statutes where people may sue the association saying, hey, you're not fully funded. Statute requires you to be fully funded. And I'm not talking in a term of art, but you need to be compliant with the reserve requirements under the statute. You need to adequately reserve, if you will, and you're not doing it. That could come from one of your existing members. As Mike alluded to before, it's very unlikely that insurance companies will ever pay a penny to try and make your reserves adequately funded, right? So the question there is, will members be doing anything more? There we go. Mitch has given some additional guidance, but anyway, will a claim by a member do anything more than jack your attorney fees, right? Because insurance companies are not going to make up your funds that would have come out of your own pocket anyway, right? At least that's what I'm guesstimating right now. I don't think any carrier would pay to fill a delta in your reserve funding. The bigger question is, what about somebody who bought in today? They just bought in today, and then the shortfall in reserves is discovered tomorrow. And they say, hey, wait a second, I bought in today. I'm really hurt by this. I didn't realize that there was going to be a $10,000 per unit assessment because the decks, for example, are unstable and the ledger boards are all rotted off, and they could fall off the building. So those things are going to be a little funkier. I think they're going to be funkier. I think, at least as I sit here right now, a court may not recognize that type of claim. But I think certainly after the time period for the catch-up period, courts will look at those types of claims more seriously. The problem with them is, I think, at least as we sit here today, they are uninsurable in a way, right? They're uninsurable because no, I don't think any underwriter is going to write that kind of policy. Um, Stakeholders. Who are the stakeholders? The engineering firms, the architectural firms, the reserve specialists, right? These are the people who are going to be out there having to get these done. Imagine how many reserve studies are going to be having to be done in the next year. I mean, Mitch and his colleagues are going to be running around the state getting reserve studies done, the reserve specialists, etc. So that's going to be an important thing. Um, are local and federal governments held to the same standard as what we're talking about here, right? Wait a second, Fran McGovern, what is the legislature doing? They're making us be properly funded, and they don't keep their own house in order. What are we talking about, right? They borrow like nobody's business, and so does the federal government. They borrow like nobody's business. There's a big difference, as you know. Number one, association government is small and close, right? It's much more manageable in a certain way, but also federal and state governments enjoy something that association governance does not, right? Which is governmental immunity. Governmental immunity. So generally speaking, you can't sue a public entity for many, many, many claims. Associations have no sovereign immunity or governmental immunity, if you will, right? So if there's an issue with a deck falling off and it should have been taken care of and somebody gets killed, guess who's going to get sued? The association, the board members, everyone you can imagine, right? If that happens with a federal or state government, there is sovereign immunity, and it's very unlikely that a claimant like that would succeed. But in the association world, they sure would, most likely, most likely. Mitch spoke to items more than 30 years useful life, right? So as that useful life, as Mitch said, gets shorter and shorter, if it's not included in your reserve study, it's going to have to be included in your reserve study. So for example, if vinyl siding has a 40-year useful life, but it's now 20 years into the association's world, and you need to address that, that has to be added to your reserve study. And as Mitch said, the later that's added, the greater your delta is going to be, right? Because your catch-up period is going to be much more difficult. You just need an analysis of what's going on out there in the field. Where do those things kind of come up? And Mitch can speak to this too. You see this in vinyl siding, sidewalks, storm drains, skylights, etc. The other thing to think about is and I know on these calls, First Friday with Fran, we often get a lot of finance committee chairs, etc. Think about how you're investing your money, especially now that money actually gives a return, right? For many years, we were on First Friday with Fran, and you were getting zero return on your investment. So think about how you're investing your reserve funds in a prudent way, and preserving capital way, but also that you're getting some return, right? Because there is return on money these days. Let's see. Here's another question. Will there be liability for representations, right? So in the developer world, the developer under existing law, even prior to this, was liable for representations made to prospective purchasers, right? That's what the whole Planned Real Estate Development Full Disclosure Act was based on. If a developer's out there building a community, building a building in Jersey City, and is going to sell his units or her units, he has to or she has to disclose many, many things, and he's held liable for those representations. Aside from the funding and aside from the structural issues, will associations be held liable going forward for representations made to its members and its potential members if they get these documents? That's an interesting kind of scary question under this paradigm, because if someone buys in and they say, I bought in reliance on the representations made to me by the association, and once I did close, I found that there was a huge gap, can and who can be held liable for that? Mike, do you want to jump on the chat there and take the first question if you haven't been answered yet?
Yep. Let me just give a kind of action item thing for everybody on. So just so everyone's on the same page, pretty much everybody, as long as you have more than $25,000 in capital assets, you must get a reserve study done this year if you haven't had one in the past 5 years. If you've had one within the past 5 years, You need to look at it and you need to start funding it in accordance with the reserve study. And as Fran mentioned before, if funding it is going to increase your budget by more, or excuse me, we'll start with by less than 10%, you have 2 years to get caught up. All right, starting now. If it's going to increase your budget by more than 10%, then it's the earlier of 10 years or the point at which your reserve fund would fall below 0. Okay, so it's the earlier of those two. So I guess the takeaway is you need to start acting on this sooner than later. The companies that provide the reserve funds, I'm sure they're going to have a backlog pretty soon. So I would suggest that everybody start talking to the boards about moving ahead. And finally, like Mitch was talking about, if you are a covered structure, right, if you're a mid-rise, high-rise, if you have steel, masonry construction, within the next 2 years, you'll have to get a structural integrity study performed. All right, so I just want to point that out as a quick takeaway for everybody. All right, on the, oh, Fran, you're muted. On the chat here, somebody brought up a point. How could you possibly say the cost would go down? How would that happen with regulations? And Mitch had touched on that. I think the long term would be a cost reduction. Is that right, Mitch?
Yeah, the only time you're going to see, I think, increases, forgetting about inflation, because that's to be expected, is for associations that weren't adequately funding their reserves and now they have to catch up. But then once they catch up, you won't have a problem. It's the associations that have been doing it and incorporating preventive maintenance where the life cycle costs will definitely go down. And by the way, I dropped into the chat box a copy of the PowerPoint, a copy of the national standards, a copy of the maintenance best practices report, and a copy of something else if anybody wants them.
That's awesome, Mitch. We will re-forward that. Let's see, Crystal, if you're out there, please re-forward that to everyone who was on the list too. So Marv's following up. Thanks, Marv. Section 7 showing on the screen, I think Mitch was showing it a minute ago, indicates that the section is applicable to any association created pursuant to the Retirement Community Full Disclosure Act. Does this mean it's not applicable to? No, it's, as Mike said, it's applicable. And the one thing that has happened here, Marv, and I haven't seen this yet, so it's a good question. And when we get a clean copy of the statute, I haven't seen a clean copy post Governor Murphy signing it, is when these statutes are kicking around the House, the Assembly, I'm sorry, and the Senate, is the various versions have underlined and bracketed language in there. If it's underlined language, if you're looking at a copy of this from the legislature's website, if it's underlined language, that means language that has been inserted. If it's bracketed language, even though language is still there, that means it's been stricken. So, for example, I don't have Mitch's copy, but I can see in my copy on the paragraph 7, it says created pursuant to Public Law 1977, C45:22A-22. But that's bracketed language. So in the final act, that language, I don't anticipate being there. You see what I'm saying?
My understanding is that they're backed up. You're not going to see the final document for at least a month.
Okay, so thanks, Mitch. So that's it's a little funky, Marv, because we have a hard time getting the clean document signed by Governor Murphy at this time. But I'm virtually certain that that's a strikeout from the copy I have.
And if I could just clarify something that Mike said, if you have an existing building that requires a structural integrity inspection based on a definition, you don't need to have one done until your building turns 15 years old and then within 2 years. So if your building's only 5 years, you do not need to have it done. It's 15 years is the cutoff. So once it turns 15, and the reason that it's very important for buildings like you guys have, because they're pre-legislation buildings, is because there's a lot of old buildings in New Jersey that fall under this now.
That's right.
That are more than 15 years old, and there weren't enough engineers to inspect them all at once. So we used 15 years as the cutoff, but within 15 years of age, within 2 years, it has to have an inspection.
Yep.
Thanks, Mitch.
So we'll just try and roll through. By the way, we will not be offended if you need to leave. We know it's Friday night and it's now 5:15, and we will have, like I said, a follow-up seminar on this. Should a question is, I think we skipped, should study be done by outside party? As Mitch said, yes, the study is required to be done by specified professionals in the statute. Go ahead, Mike.
So I'm going to skip down a couple of them because we answered some of the questions.
Okay.
How about balconies such as a limited common element where no maintenance is specified, and who's responsible, the association or the resident?
We have to be very, you're talking about for the reserve study or the structural integrity inspection, because
This sounds like from the reserve study.
the reserve study, if it's a limited common element, you have to look at the documents to see who's responsible for what. And if the association is responsible, for example, for the membrane deck on that balcony, then that should be in the reserve study.
Right, but on the structure,
The documents are, ask Fran or ask Mike to interpret your documents for you.
right, but from the structural standpoint, my understanding is, Mitch, that they're included, correct?
Yeah, what happened was that originally they were not included. And then after the collapse of the balcony down in South Jersey, we went to Singleton and we added the balconies for the structural integrity inspection. But just a little asterisk to that, the balcony is typically part of the facade. So it would not have been included. CAI just updated the public policy. Just last week it was approved. And now the national public policy includes not only the structure, but also the facade is one thing. The other thing is that there are a number of towns in New Jersey, Fort Lee, I think a couple towns up in North Jersey, that have requirements for this stuff in place already, and they include the facade. And one of the legal questions or the political questions that's coming up a lot now is, if a town has requirements for structural inspection and a facade, and it's a condo, now this law comes out, what sets precedent? My understanding is that they have to follow the state law, but if the local law is more stringent, they have to follow that. And I defer that to, that's my understanding.
So that's a whole different seminar that we could talk about.
Yeah, sure.
That's called legal preemption. There's a whole thing about field preemption, express preemption, et cetera. We can address that on another day. But
just so you're aware, because some people are in those towns, and that's the big question right now.
Right, and so the facade thing is important to talk about. And in fact, the Papelot case that I was talking about earlier was a facade case where the board was had their hands tied when trying to deal with a serious water infiltration issue and had to go forward and deal with it, notwithstanding the fact that the membership was trying to prevent them. So yeah, facade is really important, and speak to your attorneys with respect to local ordinances and the state law as well. Yep.
And if I could just make a suggestion, just because the law doesn't say it, doesn't mean you should still do it. So for example, if you have a building that falls into one of these categories and has a facade, inspect your facade anyway, even though the legislation doesn't include it. I'll tell you why. Because the facade can be dangerous. There are a number of cities, like New York City has local law 11, you have to inspect the facades, but also water gets through the facade and could affect the structure.
That's right.
So the cost of these studies, if you're doing a structural integrity inspection and you have facade, ask for the additional cost to do it, because it isn't that it's not a huge burden, and you should do it.
That's right. So a lot of the facade stuff, the early on facade stuff, wasn't talking about what Mitch just mentioned, water infiltration. A lot of the concern there was things falling off the facade and killing people on the sidewalk, right? So
I always made the argument that, all these cities have facade ordinances to keep things from falling off and killing somebody, but how many places have ordinances requiring checking the structure so it doesn't collapse on people?
That's right. That's right. So now I think Mitch's point is when you're talking facade, it's really both issues. It's the structure and it's the safety of people on the street, right? For sure. Go ahead, Mike.
Yeah, so Mitch, I think this one's for you. It says there was a lot of debate regarding the basis for the amount needed in capital reserve. One basis was the total replacement value of all building components, and the other was the amount of the annual budget for the association. Was this ever decided?
I'm not 100% clear on the question, but the reserve should be based on what it's going to cost to replace that common element. So I'm not sure what the other part of the question is. I don't know if that relates to, for example, Fannie and Freddie have a requirement of a minimum of 10% of the annual budget.
That's right.
But as you all know, 10% of the annual budget means nothing because it's not tied into the common elements. And I've made the argument to the guys at Fannie and Freddie that you say it's 10% of the budget is how you define adequacy. But what if one community has $10 million in the bank and the other one has zero in the bank? You're still saying it's adequate. So I will say, I think that the Fannie and Freddie reserve study, reserve requirements are going to change.
Right. And that, Mitch, as you know, that 10% Fannie Freddie requirement has no connection to reality.
No.
It really doesn't.
They say it.
Right. It does say it, but it has nothing to do with reality.
No, but they say that they understand that it's not related to reality. That's right.
Mitch, this is another question for you. It says, if an association updated a 2015 reserve study within the last year, but we are still underfunded and the board just approved a special assessment to fund painting of the buildings for 3 years, does the board need to do a new study and adjust the common charges accordingly?
Well, first of all, there's a gray area about painting and reserves. Now we're talking about maintenance, so it probably should be included. But if they're inadequately funded, then they need to be in compliance with the requirement to get to adequate funding. And they have a makeup period we talked about. So I would say that if they know they're not adequately funded, they need to get there.
Okay. It says, what about, and Anthony writes, what about upgrades to components? For example, if a 20-year roof is replaced with a 50-year roof?
That's a great question. That's another change that's just happened with the national standards, where it used to be you're replacing one component with a similar component. Now it's very specific that if there are upgrades for energy efficiency equipment or different things like you're talking about, the reserve study can and should reflect that if there's a discussion with the board and that's planned to be done. So absolutely it should be reflected. I mean, if it has a 50-year life, you have 50 years to collect the amount of money rather than 20 years. It's a big difference. It may cost more, but it'll be worth it.
Somebody asks, can you touch on the special assessment or loan, if that's necessary, either for the reserve funding or for structural integrity?
Well, let's go to structural integrity. It's very clear that if it's identified that there's a safety issue related to the structure, that it does not go to a vote of the membership. Fran mentioned this before. The board can make a decision for a special assessment of borrowing if it is a safety issue, and they're obligated to do it. They do not have to go by the bylaws if it needs a vote. If you're in regards to the reserve study, if your reserve, that's a good question. If I think I know what it is. If your reserve study is underfunded, do you need a special assessment to bring you to adequate funding? That's a good question, because the way it's set up is that you have a number of years to do it. If at the end of those number of years, you're not fully assessed at adequate funding, then I think there's something in the statute. It's a great question that you may need to special assess, because you're going to have to do it anyway, because you're going to have to replace something in order have the money to do it. Sorry, Frank.
I don't have the language in front of me, Mitch, but my intent, my understanding, and I think the language is in the statute that says it's supposed to be leveled. It's supposed to be leveled during the catch-up period. The intention is not to go out there, at the last minute and special assess people a ton of money.
Yeah, Fran, I actually have that language here. It says
Okay,
the
go ahead.
reserve funding increase shall be an equal line item increase in the reserve fund until the reserve fund is made adequate.
Right.
But Mike, in the next sentence, doesn't it say that if you need to, you have to special assess, you can? I thought it
Yeah, it
says
says nothing's prohibiting it. Nothing in the statute prohibits an association from obtaining a loan or special assessing.
Right.
Yep.
Right. But I think the intent is not to hold out and then zap people. So for those of you who have been in business a long time, there used to be something called a bust out for retail and for landlords. You run the place into the ground and then you sell all your units, right before everything needs to be repaired. That's not what they want to go on here.
Absolutely. The absolute goal is to get to adequate funding within a certain period of time.
That's
absolutely.
Right.
You're pretty
Mitch,
good. You still got 120 people here after an hour and a half.
I know. A few more here. So, Mitch, somebody asked, are windows, typically considered part of the structural integrity of a condominium, I guess, for a mid or high rise?
It's an interesting question, because based on the definition of the structure in the law, they are not. But I think if you look at the Jersey City or one of those statutes up in North Jersey, they do, in their definition of structure, they include windows. So it's kind of weird, but the windows are not part of the structure. Let's put it that way.
Okay. Is the balcony inspection only required for covered buildings?
Yes.
Okay. And then finally, how often does the structural integrity inspection need to be completed just on the covered buildings? I know there are specific requirements, regulations in the inspections.
The basic guideline is that within the first 20 years after the CO, they should be inspected a maximum of every 10 years. And after that, it's every 5 years. But buildings after the law was passed, their first inspection is at 15 years, at 15 years. The next inspection is at 20 years, and then every 5 years after it. For a building that was approved before, that was built before the law, which you all are, if it's at 15 years, it's essentially the same thing. The first one, 15 years, the second one, 20 years, and then every 5 years. So it's really 15 years, then 5-year increments. The wording in the legislation is kind of confusing. And the reason it's confusing is because we went through so many iterations to get to something that, but that's where it landed.
Yep. Okay.
Okay.
And we'll have to check that. We'll have to, because it's even more confusing, honestly, Mitch, in the marked up legislation. I really want to see the clean legislation on that because it is really
It's
confusing.
impossible to do what you said because whenever there's a bracket, it's not really there. Take it out.
No, that's right. It's very tough to read because the way it's reading right now, it looks like, 15 years if you're a brand new building, less than 15 years, then 1 day, then you're looking at 1 year, then there's a whole another provision on the 2 years of the effective date if you're a very old building, right? So we'll have to see what I hear what you're saying. I just want to see the clean language there because it is.
Yeah, but the basic concept always was that buildings up to 20 years old, a maximum of 10 years, and after 20 years, it's every 5 years. But then they dropped in the first inspection at 15 years, which is what confused everything.
Okay.
All right, looks like we have one last question. It says, will the law allow for a special assessment or a loan if the association does not allow for special assessments unless the membership approves it?
Safety, yes.
Right, so for structural inspections, like if you get your structural inspection and there are certain items that need to be addressed, like Fran and Mitch had mentioned earlier, I believe the answer is you're permitted to do that without any membership approval.
If it's a safety issue, yes.
Right.
Yeah.
When it comes to funding the reserves, however, it simply states that the statute does not prohibit an association from obtaining a loan or special assessing its members, which to me then means we need to look at the governing documents and determine what requirements are set forth in there to determine whether or not we can special assess or obtain a loan.
Mitch, one last thing is there's a question from Chris Nicosia. If an inspector recommends destructive testing or invasive testing as part of their inspection report, does the association have to do it if it's a covered entity, covered building?
It's a good question. You're talking about for the structural inspections.
Structural, that's right.
So the structural inspection says first stage is what's called a preliminary inspection. This is all based on American Society of Civil Engineering standards. But the first inspection is what's called a preliminary inspection, where you look at all the structure visually to look at it. If you identify anything that's a potential problem, then you're required to do what's called a detailed inspection, which may include invasive testing. But it's a process, but it starts with the preliminary. And in the law, it says preliminary and then detailed. It does refer specifically to that.
Okay, so basically though, if an inspector finds an issue, I think the answer is yes, you're going to have to open up something, right?
Yeah, and the other question was, which ties directly into that, is what if you can't see the structure in a part of the building? You have to take it apart to see it. The answer is no, but if you're looking at the floor in the building and you're seeing it sagging or something's moving, then you are required to open it up to look at the structure to see what's causing the problem.
Okay. All right, it's an hour and a half. Thanks, everyone. We still have over 100 people with us. Thanks so much for coming tonight. And we will see what we're going to do, whether or not we're going to do one of these next week or not. But it's great seeing everyone, and have a great weekend. And we'll certainly see you soon. Thanks again. And thanks so much to our special guest, Mitch Frumpkin. That was a lot of information. Really appreciate it, Mitch. And thanks again.